So I'm gonna restart the recording. So I hope everyone had access to yesterday's presentation. I did post it on the Moodle site. I also hope people have access to the recording from yesterday because it did get uploaded, as far as I'm aware, automatically, and hopefully this will as well. So teething problems will be sorted. Um, Let me share my screen and we'll get started on, as you were, the latter part of yesterday's discussion. What I want to do is I realize I've kind of gone through relatively quickly that last bit about the different regional definitions and why they matter. So I just want to spend a few minutes just unpacking a bit of that. So returning to that final slide, and then we'll continue from that point onwards. So you can again tell me if you're able to see this properly, and I'll just share it in presentation form. Can everyone see this? Great, and
Yes.
you can't see a subsequent slide or what have you. Okay, fantastic. Okay, so and I can see you on the side. So as per usual, if you have a question, you can either raise your hand through the function or just jump in, and we'll deal with that. So I just want to talk about this kind of the dynamic between the global regime and the regional protection regimes. Uh, I mean, as we saw in two of the three regimes that I've uncovered or discussed, the definition of who is a refugee as such is a more expansive one, right? So the label you get with all the significance that that has, and with the rights that arguably are supposed to be attached to that, which we'll come to in a subsequent seminar, um, are not supposed to distinguish between somebody who is a refugee based on the 51 Convention or somebody who qualified under those more expansive versions. The European Union chose a different modality, right? It chose to say we acknowledge that the 51 Convention is too narrow in terms of protection, so that it doesn't grant protection to everyone who needs it. And hence, we create a separate category of beneficiaries of international protection, which we call subsidiary protection. And at the very least, at the start, that category actually did carry fewer rights and was less secure. So it actually was quite significant as to whether somebody was assessed under the 51 Convention or under subsidiary protection. And that prompted a question, right, which UNHCR engage with, which relates to the second bullet point here on your slide, this notion of the hierarchy, which prompted UNHCR to say the following, and this is in guidelines on international protection that relate to displacement from conflict. I bring this given that those are the guidelines we will be discussing later on today in relation to that topic. And what they say here is that in applying the refugee definition, a sequential approach is preferred, whereby refugee status is initially assessed at a 1951 convention before an assessment is done under regional definition. And that is because of the universal character of the definition, the primacy of the convention, and the explicitly complementary character of regional definitions. Now, there's a difference here, I would argue, between why it matters to go sequentially in relation to the 51 Convention in the European Union and why it's important in other regions. In the European Union, it still is the case that subsidiary protection is a less desirable status. So, for instance, it affects the length of time one is able to stay. It doesn't come with that indefinite nature that we'll come to discuss in the session around temporality and kind of precarious nature of refugee status. So subsidiary protection is renewable, but it comes with a term limit. It also comes with fewer rights, for instance, in relation to things like family unification. And it used to come with fewer other rights on the right to work, housing, etc. And those have been now streamlined. So in the EU, it's very clear that if you jump through the through or across the stage of assessing whether somebody meets the 51 convention, and you go for the easier, sometimes subsidiary protection route. For instance, this was something that happened in various EU countries in relation to Syrians in the late 2010s. They say, well, it's obvious we can't return somebody to Syria. It's obvious the conditions of the armed conflict are such that they face threats. So we're just going to give them status of subsidiary protection under Article 15C, so under the provision that relates to the effects of armed conflict, rather than attempt to assess whether, for instance, we've got a Yazidi woman here, Islamic State is controlling the area in which she lives. It's very obvious she would meet the 51 Convention definition, but it would take more effort and time and energy and administrative constraints to go through that assessment. So we'll just jump through that. And that was problematic in my view, and not just in my view. So in the EU context, there are concrete ramifications in the state that grants someone protection of whether they get refugee status or subsidiary protection. When it comes to the African Union definition and the definition in Americas, because it's the same status as a refugee, then supposedly it makes less difference what was the route through which somebody got protection. But where it would make a difference is if that person were to say want to travel to another country and want that country to recognize them as a refugee, and then that country, if it's outside the region, might say, well, under our criteria, you don't meet the refugee definition because we don't have an expansive definition of a refugee. And so it may very well be that there are people in that category that legitimately they do not meet the 51 convention definition, and they do meet the regional definition. In fact, we would expect that to be the case because we would expect that definition not to be redundant. But in the cases where somebody meets both, which also exist, then the correct route is the one that allows for protection to be granted under the 51 global primary document rather than under the regional definition. And indeed, specifically in the European Union, what those countries that I've described have done is arguably a breach of the treaty itself, or rather of the directive that follows from the treaty, because the qualification directive, now regulation, as I've suggested yesterday, actually says that you have to follow a sequential operation in your refugee status determination. And so if you don't do that, at least in principle, that is not following the correct procedure. So that's a point I wanted to intimate. I also wanted to say just something more about the justifications, right? And about this idea of individualized versus group assessment, right? Because to some extent, both the 51 convention and those regional definitions all require an individualized assessment, because it is the case that you need to show that this particular person was compelled to leave under the OAU convention or had fled as an individual under the Cartagena Declaration, or that there are serious harm that they face. There's a real risk that they face that serious harm in their country of origin under the EU qualification now regulation. So arguably there is an individualized assessment, but many people would argue the sort of circumstances that are described in these definitions, so having indiscriminate bombing or having a event seriously disturbing public order, are the sorts where really what you're looking for is an objective assessment. You're looking for seeing were the conditions such that somebody would be compelled to leave. And it's not really a question of discrimination or a question of somebody being treated worse than other people within the same society on grounds of their sexuality or race or religion, etc., but rather that they are living under conditions that other people might be living under as well. perhaps everyone the state's living under, but there are such that would prompt a forced migration. So there is a bit of a tension there. I would suggest that between an attempt to suggest the 51 Convention definition and and those regional definitions are all about individuals. They're all about protecting specific individuals and an assessment of individual circumstances, and the realization that this type of circumstances that are outlined in the regional definitions lends themselves often, if not always, to a form of group determination. And I make this point partly as a segue to the later discussion of what happens in conflict, because situations of conflict are ones where very often the idea that you would engage in individualized assessment sits uncomfortably with the reality that you've got a large number of people leaving one place at a particular point in time under very similar circumstances, right? So there's a tension that I just want to, as you were, make you aware of as we proceed, and I hope what I'm saying makes some sense at least. Any questions or clarifications on this, and anything that you've found in those definitions that you think requires discussion?
So in all cases, there is an individual assessment. Is that what we were saying?
So look, yeah, so that's the difficult question, right? So in theory, right, if a country decided I'm gonna grant any, to relate to the discussion we had yesterday also with Aviatar, like I'm gonna grant anyone who's a woman who's just been kicked out of her job and forced to stay at home and can't access any services without a male chaperone, etc. In Afghanistan, any woman who comes in those circumstances and is from Afghanistan, I'm gonna assume meets the 51 Convention definition. So I'm not going to spend time and energy and resources in assessing. It's very difficult to say to that state, no, you must actually undertake an individualized assessment. In principle, the convention would expect that to happen, partly because some people might be excludable, right, from status. So if you think about the example of Afghanistan, you'd be less likely to come across someone who would fall in what I've just described into the exclusion clauses. But you can think about, back to my example of Syria, that there might be groups of people who you would think everyone belonging to this group would meet the refugee definition, but some of those people who belong to that group actually should be excluded because they've been involved, say, in war crimes. And so, uh, at least in principle, the correct modality would be to assess those two questions in tandem, right? The question of exclusion and inclusion in tandem. I don't want to uh, fully jump the gun on our discussion on exclusion, because the question of whether there's a sequential approach there as well, or whether you first assess whether somebody is included only to then assess whether they should be excluded, or whether you do it in the reverse, or whether you do it in tandem, is not determined by the convention, right? So it's kind of left to individual member states to operate, and it's contentious, right? So um, all I'm saying, I suppose, in response is that from an inclusion perspective, if countries do a group form of recognition and give everyone in a certain category protection, it's very difficult to kind of counter that with saying, no, you should have denied some people protection. At the same time, the nature of refugee protection, if we look, and this will be a segue to the discussion very soon of the specific components of the refugee definition. The refugee definition speaks to a well-founded fear of persecution, right? So it doesn't just say persecution has to be well-founded. It says there needs to be a fear of that persecution, and that itself suggest a degree of subjectivity, a degree of individualization. So it's a bit of yeah, it's a bit of an unclear or disputed point. And that's why I'm presenting it in the way I am, not necessarily to determine, but to just give you a sense of the debate around it, I suppose. Um, any other questions before I move on?
I have a question.
Sure.
Maybe you've said something about this, so I'm not sure, but is the protection under each definition the same? Do I have any interest to be a refugee under the 51 convention or the guidelines? Is there any way to do both? How does it work?
Yeah, so that's the point I made kind of partly earlier, right? That under the regional definitions, because somebody receives refugee status, whether it's through an assessment of whether they meet the eligibility criteria under the 51 convention or whether they meet the extended or expanded definition regionally, then in theory at least, it should make no difference in the region, right? It would potentially if that person were to travel for the reasons I've articulated. In the EU, there is still a difference, right? Those statuses are different. They also translate in member states' legislation often to a different set of um, ramifications in terms of access to certain services, etc. There has been a convergence, so that's the process I was describing from the original, the first time this subsidiary protection was introduced, which dates back to 2004. There was a very big difference, and that difference has shrunk, right? So it's not as if the difference is has disappeared, but it's not as profound. But similarly, if somebody gets subsidiary protection, it's not a concept that is recognized. Say they were to travel to Australia or to Canada or to South Africa, or that status doesn't mean anything in terms of international law, right? And so it's not an argument, or I'm not making an argument here, absolutely not, to say that it's bad that those regions have created additional structures. Absolutely not. It is just to say why the rationale of saying you should start from the 51 convention, see if somebody meets that, and only if that's not the case, move on. Why that rationale, to me at least, makes sense, right? Did that answer it broadly?
Yes,
Great.
thank you very
Yeah,
much.
perfect. Okay, so let's move on then to what I want to discuss further. And I want to start with this notion of what do we perceive to be persecution, right? So let's say the well-founded fear component is this alchemy or this weird combination of um, having to have some subjective basis that is assessed through your often asylum interview, right? So different states do it differently. It relates to Itamar's question around whether there's an individualized assessment. This is where it would happen, right? You would assess the credibility of the fear of, say, an individual who is fearing on the basis of their religion that they would be persecuted. Are they genuinely practicing their religion? Is it really the case that for someone like them, there would be these ramifications if they were to be returned, right? So the well-foundedness is, at least in principle, objective, right? It's an assessment. You often have something called country of origin reports or country of origin assessment, which states of asylum, if they are if they have good practice, right, which not all states do, they would often produce those internally as a matter of guidance for their decision makers. So you've got somebody sitting in the Ministry of Home Affairs or the Home Office, depending on jurisdiction, and having to look through an assessment of an individual case, and they know nothing about that state. And so they go on to a file. They say, well, this person comes from Cameroon. Cameroon at the moment has these and these conditions in relation to these groups that appear in the convention. And so on its face, right, prima facie, you would assume that someone who meets these criteria, ticks these boxes, is likely or is less likely to be persecuted, right? So that's often the first stage. Some countries have these guidelines, some don't. Um, some countries have guidance for certain countries, but not for others, right? So the picture related to a point I made yesterday, there's a great deal of diffusion in practices, which again is not ideal because it also would mean potentially that what we deem to be objective is still in the eye of the beholder. There might be very different reports. I mean, one classic example which Shachar may come back to next week when we talk about Israel, asylum seekers in Israel, was very different approaches to how one assesses the circumstances for young men leaving Eritrea, right, in different jurisdictions, right, and whether that whether there's an assumption that if they were to be returned, they would face harsh treatment or treatment that amounts to torture or inhuman and degrading treatment, how they'll be penalized for having evaded military service, what are the conditions of military service. So I've read country reports that took different views on what is arguably, an objective question, right? So um, you should be able to assess it. The problem for states, and it's a genuine problem for the whole asylum system, is that you are engaging in a process where you are trying to assess what the circumstances are somewhere else, right? Where you may or may not have good information. This is often why you also, in the decision-making process, when it gets to court, you have expert opinions. And as I've suggested yesterday in an answer to a question, I think Dana was asking a question about the West Bank, and I said I've been involved in a couple of cases relating to asylum seekers from the West Bank, right? So I was writing an expert opinion as ultimately there was then submitted to the court and was part of the base for the court's decision. Not least because in those cases, actually, there was no country of origin report produced or available to the decision maker by the state itself, right? So, you might say sometimes that works to the benefit of an asylum seeker if the state doesn't have any documents, because if the state does, then it tends to um, defer to its own assessment, right? If there isn't one, then there might be more scope for the asylum seekers themselves to be bringing information in. The overall point to be made about, and this is, I'm making this point now, it pertains to all elements of the refugee definition, is that the Refugee Convention is very unhelpfully telling us absolutely nothing about how the refugee status determination process is to happen, right? We know nothing about who is to conduct it in the state, what are the stages in which it should be conducted, what are the specific parameters they need to assess. We also don't have, and I'm sure you'll be familiar in domestic legislation and sometimes in treaties as well, we would have a section of the treaty or the legislation that would define terminology, right? Would tell us in this treaty, persecution means X. In this treaty, fear means Y. Sometimes you have, as Israel does, a law that is of general application that tells us if a specific law doesn't define a term, this is what we expect the term to mean, right? It's the interpretation legislation in Israel, right? There isn't an equivalent here, right? There isn't an equivalent element that we can revert to that is authoritative. What we do have is the UNHCR handbook from 1979, having been revised in 2010, and UNHCR guidelines on specific areas of law. In those circumstances and in those instances, we do have some basis for our assessment, but those, as I say, are not authoritative or decisive. So states may or may not agree with UNHCR's assessment. So I will be, as we go along, kind of the next section, I will be referring to what UNHCR believes persecution means or believes multiple nationality means. But those are UNHCR's views, right? Those are not necessarily binding on any individual state, and different states may take different views, right? So this is by way of a general introduction to this challenge, right? We've got an individual applying for asylum. They say, I have a well-founded fear of persecution on this ground. How do we understand any one of these terms is not something the convention gives us an answer to. It's something that case law, jurisprudence, assessment has been developing, but developing in a diffused way, right? That's the overall message I'm conveying. So with that in mind, let's see what is the, I think, I don't want to say consensus view, but certainly the dominant view as to how we understand the concept of persecution. And a clear reference to it appeared in a case from the UK House of Lords when it used to be the highest court in the land. I mean, that changed in 2009 to the Supreme Court with the same composition, just moving, as you were, physically across Parliament Square in London. And in a case called Islam and Shah, the court developed this framework of saying persecution is a combination of two things. You have to show that the person would suffer serious harm, and you have to show that that is a source of a failure of state protection, right? And of course, failure of state protection may be a result of the state itself being persecutory, and it may be a result of the state failing to protect from other harm. So that's the point about non-state actors that I will come to soon. In this specific case, which I actually will come back to in a few minutes when I talk about membership, particular social group, because it relates to that as well, was a case where you had two women from Pakistan who were subjected in Pakistan to serious physical abuse by their husbands. They were forced to leave their home. They applied for asylum. They said if they were to be returned to Pakistan, they'd suffer from domestic violence. There will be no state protection to them, and there will be severe sanctions from false allegations of adultery that are made against them. And the House of Lords, recognize gender as a protected characteristics and women as a particular social group, which is, as I said, the point I'll come back to, but also said this is a circumstance where we deem the type of treatment that will be meted on these two women to meet a serious harm test. And the state, cannot guarantee 100% protection from domestic violence. Of course, it can't, but it has to show that it's serious about tackling it. And so, if you are in a position where if somebody goes to the police and they complain about domestic violence, they get brushed off, or worse, they get themselves be accused of various falsities, right, as was in this case, which means there is no recourse in the criminal justice system to somebody in that condition. Then you've got a combination of the failure of the state to protect, but also of the serious harm that follows from it. And to try to think what are the sort of circumstances that amount to this type of harm, UNHCR offered three alternative scenarios. It says the perhaps most straightforward scenario is when the serious harm is either serious physical harm, right? So actual physical violence against someone, loss of freedom, or other serious violations of basic human rights as defined in international human rights instrument. And here, often the reference would be to think about instruments like the Covenant on Civil and Political Rights. I appreciate most of you haven't studied international human rights law, but in international human rights treaties like the Covenant on Civil and Political Rights, there are certain rights that are deemed to be quote unquote non-derogable. That is, that these are rights that you have to continue to provide, to protect, not to interfere with, even in circumstances of conflict or violence or emergencies that threaten the nation, right? Where certain other rights are deemed to be derogable. So one classic example, the right not to be subjected to torture is deemed non-derogable. The right to freedom of association or assembly is deemed to be derogable, as many of you will have experienced, and as you will be familiar with recent litigation, even in Israel, around demonstrations at time of conflict. Right, those would be deemed to be derogable, but if somebody were to be tortured, the fact that there's conflict doesn't justify that, right? So that's often been seen as the way you would distinguish under this UNHCR category what are basic human rights and what are others. it's an inexact definition, and of course it's UNHCR's proposition, and one doesn't have to necessarily accept or follow it. So that's their first category. Their second category is what they call discriminatory treatment, which leads to consequences of a substantively prejudicial nature. And I think maybe Aviatar or someone else asked yesterday, how would we kind of differentiate ultimately if there's a group that gets discriminated? And UNHCR's response to this is to say discrimination alone may not be sufficient to amount to a threshold of persecution. You need that discrimination to have consequences, and they have to be of a substantially or substantively prejudicial nature to the ability of that individual to live their lives in that country. Again, you may agree, you may disagree that that should be the right benchmark to apply. The convention doesn't tell us what should be the benchmark. And then the third proposition from UNHCR is that there can be what sometimes people call, and apologies if that's an offensive term for anyone, but a form of Chinese torture, right? Just like death by 1,000 wounds, right? So you've got a combination of numerous harms, right? So none of the specific harms if you just zoom in on how people are treated at work or how people are treated on the street or how they're treated by their peers or how they're treated in the media or how they're treated by the official authorities. None of these on its own would be sufficient to constitute persecution. But if you take them as a whole, you look at them in the round, you say there's a general atmosphere that has a cumulative effect that creates a well-founded fear of persecution, right? And there may be a lot of instances, particularly, by the way, around issues such as sexuality or gender, where we might say that is actually the case, right? That it's not that there is one piece of legislation that if we just look at that, that is sufficient for us to say there's discrimination. But if we look at the round, we might say we've met those conditions, right? So that's UNHCR's idea, and I mean an interesting example, which again I would come back to as a case, relates to sexuality, relate to a case before the Court of Justice of the European Union, which to remind you is at least attempting to harmonize protection standards across the EU. So that's quite a lot of countries and quite a lot of asylum seeker cases, so significant to that effect. And what the Court of Justice in this case, which concerned three asylum seekers who were all gay from three countries in sub-Saharan Africa, Sierra Leone, Uganda, and Senegal, all of which had legislation that criminalized consensual same-sex between adult males. And the question here was, is it enough that there's criminalization, or do we need does the asylum seeker need to demonstrate, or do we need to have information to suggest that that law is actually enforced? So is it enough for that law to be on the books, or does it need to be enforced? And to assess that question, in part, the court started by saying, for a violation of fundamental rights to constitute persecution within the meaning of the convention, it must be sufficiently serious. Therefore, not all violations of fundamental rights that are suffered by a homosexual asylum seeker will necessarily reach that level of seriousness. And they go on to say later, we need to actually demonstrate that somebody is that the legislation is being enforced, and not just that it's being on the books. And I wrote about this in part, which is a point I'll come back to a bit later. But I just want to demonstrate, that distinction between saying we deem the practice in another state to be wrong. We, in our own domestic jurisdiction, would not accept that sort of practice, but we don't deem it in certain circumstances to be wrong enough, right? Or to have severe enough consequences to meet a threshold of persecution, right? And that gap, which is often a real life gap, right? Between people who are, between the treatment that you would expect the state to provide its own residents, right? In many cases, and the treatment that it deems to amount to persecution when it happens somewhere else, right? That gap is challenging, right? And as I said, the piece that I've written, which I'll share a link to, was published a few weeks ago. Um, Addresses or seeks to highlight this challenge. Say, what does that tell us about universality of rights in the eyes of a state where you would expect different treatment, of itself, as you were, than you would in order to award somebody asylum when they come from elsewhere. There might be good policy justifications for this. There might be a lot of people, including in Discuss, who would actually say, well, that's the only sustainable way of not having very large numbers of people having suddenly eligibility simply on the basis of different legal standards in different countries. But it's a genuine challenge again, which I think I would be remiss if I didn't point to you. So that's a point about persecution, and I want to kind of go on to say a few things about how we think about refugee status and how we think about persecution within this context. And the first thing to say is that persecution is in the eyes of the persecutor. Now, this may be either intuitive to you or maybe counterintuitive to you, but the point here is to say somebody may actually believe that they're not, for instance, practicing a certain religion that in a way that's prohibited by law. But if the authorities believe that what they do is a breach of the law, then it doesn't matter what the individuals themselves think. It matters what the authority think, because what the authority think will affect how that person will be treated. What will be the consequences for that person to be returned, right? So persecution can be based on imputed or perceived grounds rather than necessarily on actual ground, right? There might be circumstances where people, for instance, have no political views. There was a famous case in the UK of somebody claiming asylum saying, I had no position personally as to whether I like Mugabe or don't like Mugabe, right, when he was the leader of Zimbabwe. But they had this practice in various rural areas in Zimbabwe where supporters of Mugabe's party, ZANU-PF, would go around and would ask people at checkpoints to sing a certain song that expressed support for Mugabe. And if people didn't sing it, they they would perceive them to be hostile to the regime, even if they might be neutral, right? So again, the mere fact that you don't perceive yourself to have political opinions that are oppositional to the state or to have practices that are oppositional to a certain group, if that group perceives you to act in that way and that lead that group or the state to persecute you, then that is the assessment that the decision maker has to engage in, right? It has to engage with what will happen to the person in real life, as you were, rather than necessarily what that person really is, right? And that's again, there's a degree of tension there, right? How do you assess whether somebody would be perceived to be an opponent of the regime, right? That might not always be easy. It's much easier if that person genuinely is, right? If that person is an activist, that person posts against the regime, that person that organizes demonstrations. But there might be circumstances where even people who don't do that are subject to persecution, and that's something the convention, at least in principle, has to accommodate and must accommodate as a matter of good practice. Um, the point I made earlier and yesterday as well about the nature of the persecutor, the idea that the persecutor can be also act as others in the state, is now, I think, not really disputed, right? So I'm not familiar with jurisdictions that still take what's you can see on your slide has been referred to as the accountability or attribution approach. So the idea that you need to be attributing the persecutory act to the states, that international law, that the convention is ultimately about the behavior of the state and not about the behavior of non-state actors. States generally now, in their assessment, adopt what's referred to as the internal protection view, which is the view that says what really matters is whether somebody receives protection. In fact, right? In actuality, in that state, and that's very much reflected in the language, for instance, of the EU qualification regulation, which speaks about actors of persecution or serious harm, right? Remember, the EU, because of subsidiary protection, there's this concept of persecution, and there's a concept for subsidiary protection of serious harm. But they say the same thing, right? They say, in relation to somebody who would qualify, quote unquote, as an actor, it would first and foremost be the state. It would also be parties or organizations that control substantial parts of the territory of the state. And it can be non-state actors if you can demonstrate that those actors are ones where the state is unable or unwilling to provide protection against persecution or serious harm that is meted by those actors, right?
So,
Sorry, go ahead.
So for example, if I have like someone who wants to kill me because
Yes.
I don't know, let's live with his wife or anything, and he's follow after me, and the states want to protect me. They send cars, but they probably say they can't do it. If you stay in this country, you're done. I can seek asylum as a refugee by this qualification.
So that's a debatable. So obviously, I mean, the cop out of your question is that it depends on the specifics, right? So in principle, if you have if the state had said we have gang violence in this country and we're trying our best, but this is still a very, very dangerous place, and certain neighborhoods are no-go areas for the police, and if you are under threat in that area, then we have our full sympathy to you, but there's nothing really we can do, which is arguably the case in certain areas in or was the case in certain areas in Central America, perhaps in certain areas in places like Colombia, perhaps in certain areas in South Africa and others. And if that is the case, and you're from that area or from in those circumstances, then on the basis of this test, right, objectively, if you are targeted and by those gangs and the state will not effectively be able to help you, even if it wants to, then you would be eligible for protection. What this isn't doing, this is why, I'm saying it depends on the circumstances. It isn't a statement of saying a state that is not able to guarantee 100% protection from crime is one that is unable to protect you. Of course, that cannot be the standard. It's also not the case in many of the states that grant asylum, right? It's not the case that there is no, say, gender-based violence in the United Kingdom or in Israel or in the United States or what have you. It's not the case that every form of gang violence is 100% tackled by the criminal justice system. In a way, the test, and this is, of course, a contentious question, right? So your question is a good one, right? The test would be, is the state genuinely trying, right? Is it devoting the sort of resources you would expect it to? Is it treating this as a problem? Is it determined to try and solve it? And is it making us a good enough effort that we would consider it to be a situation where a threshold of persecution isn't crossed, right? Right, go ahead.
But in this sense, there can be a difference also between if it's a large organization or corporation that controls a large portion of the state's land or economy, between just one person or a gang that is prosecuting the individual, right?
There would be
I
absolutely,
mean, even if the state wants to protect the others, if there is like a large other terror organization that control parts of the country, like in Somalia or other places, that is prosecuting someone, it's different than some, even if it's a serial killer, even if it's very proficient and smart and
that's
different
right.
things.
That's right. But that's why organization controlling parts of the state are deemed to be equivalents of the state, right? In that area,
Yeah.
right? So when Islamic State was controlling part of Syria, it really doesn't matter or didn't matter what the position of the Syrian state was on Yazidi women. It mattered what Islamic State thought about Yazidi women, right? So when you've got an area that's under effective control, then you need to pragmatically treat the organization running that area as if it's the state. So those are the easier cases. I think the harder cases are cases where it's not as clear cut as that, right? You don't have
Yeah.
you don't have that scenario, but you still have threats to people from non-state actors, and the question is how much the state is, what the state is doing to try and
Mm.
address it. Does that make sense? Yeah.
Yeah. But I mean, there always be like border cases. I mean, think about the
Ab-
Italian mafia, for example,
Sure.
is that it doesn't exactly control, it didn't exactly control New York in the 30s and 40s, but it was a very dominant force that
Sure.
controlled politicians,
Sure.
stuff.
And
So
sure,
it's
absolutely. And
complicated.
no, well, that absolutely, and I mean, the borderline cases are the interesting ones, but the ones to which we don't have an obvious answer from the convention. I think, to me, ultimately, you need to kind of think back to the rationale for protection, right? So why is it that we step in and provide the so-called surrogate protection to someone in these circumstances? And my view would be, um, you're assessing whether that state is generally functional, right? Whether that state is making 100% effort, even if it's not having a hundred
Mm.
percent result, because no state manages to get 100% result on crime, right? And arguably, I mean, this is now me and not the Refugee Convention. We don't want a Bukele type approach to law and order, right? We don't want the way to reduce crime by 98% or 99%, as El Salvador managed to do, is by having incarceration under horrible conditions and no law, no rule of law in the prosecution processes, and essentially unlimited powers for the police, right? So that's not the benchmark we want to set. We don't want states to think that or we don't want decision maker to say we expect states to reach that result of no crime, whatever the means they use to get there, right? That would be throwing the baby with the bathwater. But so you need some sort of a framework that is workable, but it's difficult, right? So those are the difficult cases. As I often say, the move from having just the state as the actor of persecution to having non-state actors is a welcome one, because it recognizes the reality, which is that a lot of people are persecuted not by the state. It is still the case that the most classic cases of persecution that the convention was directed towards are the ones committed by the state. So the classic scenario, when people have in mind the political dissident from the Soviet Union who were thrown into the NKVD interrogation room because they wrote a poem that criticized Stalin, right? So that's the sort of thing we have in mind often. And those cases exist, right? And they continue to exist. And tragically, they exist in very many countries still. But there are a lot of other people who need protection under the convention. And so the development in interpretation makes for those borderline cases, which are difficult. So yeah, absolutely acknowledge that. So I want to talk finally in this bit of definitions around membership of a particular social group, and what that means, right? What is that category, right? Because we said there are five categories of refugees, right? So there of categories. There's race, there's religion, there's nationality, there's membership of a particular social group, and there's political opinion. And it's not as if the other four are clear-cut and obvious, and there wouldn't be borderline cases. There wouldn't be questions as to what qualifies as a religion or what qualifies as a race, even what qualifies as a political opinion. All of these are also would have their edges, right? But the category which by definition has not had a definition is that of a membership of a particular social group. That is uh, a more basket tape case rather type definition. And so we need to try and unpack it, try and understand what that translates to. And what UNHCR has said about this is that there is no closed list of what groups may constitute particular social group within the meaning of Article 182. The convention includes no specific list of groups, nor does the ratifying history reflect a view that there is a set of identified ground. Rather, we should see it in an evolutionary manner that's open to diverse, to changing nature of groups in various societies and evolving international human rights norms. And this is in many ways a reference to changes that have occurred very clearly, and we all know this because it happens around us and within our own societies in approaches to categories such as sexuality and gender identity, and such as sex or gender itself as well, right? So in those categories, if we are honest with each other, which we must be, in 1951, when the convention was drafted, nobody would have considered, none of the drafters around the table would have conceived of the mere criminalization of homosexuality as a ground for granting someone asylum. And that is because virtually all the countries, or almost all the countries, at least on their books, had laws that did exactly that, right? And it was still a case where there were very entrenched forms of discrimination against women on ownership of property, on voting rights in many of the signatories. The original signatories to the convention in 1951, there was still no equal voting rights to women, and in other forms, the ability to pass on nationality to children, the ability to sign various documents, etc., the effects of marriage. So it's very clear that at that time, many of the practices we would today consider, or many of us would consider today to be persecutory, were not deemed to be persecutory. And so to some extent, what this convention has done, and this relates to a wider debate in international law, which some of you may be familiar with if you've studied international law, about how we think about treaties more generally, how we interpret treaties. Do we have a dynamic interpretation, an evolving interpretation, or do we opt for a so-called originalist interpretation? Do we kind of stick to how terms were understood at the time they were understood at the drafting point? UNHCR's position is very clear that you need to be evolutionary. I happen to think that's the correct view. And it's also, I think, manifested in having a category by the drafters deliberately, like membership of a particular social group, which was intended to allow for that to happen. Otherwise, why would you have a category that is loose, that is open, that is not clear in terms of its designation, right? So, so what does that then translate to? Right. So if we look at the typologies, because it still is the case that we need some definition of what a particular social group is, right? So we can say several things. We can say that there are two broad types of groups. One is that there are groups that are defined by their innate or unchangeable characteristics. We often call this the immutability or protected characteristics approach. So, so characteristics that are either unchangeable or ones that you shouldn't be expecting individuals to forgo and change because they're so fundamental to their identity, to their conscience, or the exercise of one's rights, right? I'm now reading from the UNHCR definition you see on the screen. The second is that the group may not have necessarily immutable characteristics, but it has a common characteristics which makes them a cognizable group or sets them apart from society at large. There's a social perception, in other words, that that group is distinct, right? And the very way I think in of drawing a distinction or the easiest way of thinking about what wouldn't be a particular social group is, let's take the group of people who drive above the speed limit, right? And get fined as a result because they breached the law, right? The only thing that is mutual to all of those people is the fact that they are being prosecuted for having committed a traffic offense. But there's nothing else that binds this group together. If there wasn't an offense, there wouldn't be anything else that characterizes them as a group. They're not different from society at large. They don't have any immutable or protected characteristic. And so it would be absurd for us to say that the group of people who are driving above speed limit are a particular social group. In contrast, you go back to a case in 2002 by the Chief Justice in the Australian High Court, Justice Gleeson, and she said at the time, it is power, not number, that creates the condition in which persecutions may occur. Women in any society are a distinct and recognizable group, and their distinctive attributes and characteristics exist independently of the manner in which they're treated, either by males or by governments. And Lady Hale, in a case in the UK, then still House of Lords, in 2006, said the world has woken up to the fact that women as a sex may be persecuted in ways which are different from the ways in which men are persecuted, and that they may be persecuted because of their inferior status according to their gender in their home society. Right? I'm not sure she would use the same language today, but I think we all understand what she meant there, right? And so some of the forms of, for instance, gender-based violence may be ones such as female genital mutilation, may be ones that are unique to women. Some others, domestic violence can occur between people of the same sex, can occur between people of opposite sex, can occur in different directions. So it's not necessarily that someone is being persecuted always on the basis of their particular social group. But it is the case that we need to recognize that there are circumstances in which people are treated worse on the grounds of their gender or their sex, or indeed their sexuality. And this is where I want to move to kind of just give an example around sexuality. So in a case in the UK Supreme Court now called HJ Iran and HD Cameroon, which is a case where the main ratio of this case, which is a good ratio, was that gays don't have to hide their identity or conceal their identity in order to avoid persecution, that the expectation that they would do so, saying someone can be closeted and hence be protected in a society where if you're closeted, nothing would happen to you, but if you're not, then you would be persecuted, then that notion has to go, right? That people should be allowed to be who they are, where they are, and shouldn't be expected to conceal their identity. But to get to that point, the court said in 2010 that a group based on a common characteristic of sexual orientation may be included in a particular social group that is in need of international protection. And the court then, and this is, I would say debatable in terms of how it decided to couch this, but it said the group is defined by the immutable characteristic of its members' sexual orientation or sexuality. It's a characteristic that may be revealed by the way in which the group behaves, and in that sense, it manifests itself in behavior and less immediately visible than, for instance, a person's race. But that to pretend it doesn't exist or that it can be suppressed is to deny the members of this group their fundamental rights to be what they are. And this is a segue to which I want to move, which is to say this perception around sexual orientation, whether somebody's ability to express themselves, to behave according to what they deem to be their orientation, that is the perception in countries which protect same-sex and sexuality rights. But it's not the perception in many other countries, including many countries that have signed the Refugee Convention. So I'm going to show you two maps, which I think are quite stark. This is a map of places where there's still criminalization of consensual same-sex sexual acts, right? Most of those countries are in Africa and in the Middle East and in Central Asia. And there are different gradations here, from the death penalty onto de facto criminalization. And the patches in white, which are most of the countries in the world, but I would say only about 2/3. So 1/3 of the world has, in one form or another, criminalization. Now, this is the flip side map, right? Those are countries where same-sex couples can either marry or be civilly unioned and have equal rights. In fact, and there's almost, well, as you would expect, there is no overlap at all between the two maps. There are some countries that fall into neither of these categories, where there's neither criminalization nor are there protection. They fall somewhere in the middle. Now, why does that matter? It matters because if you've got someone fleeing a country where there is, for instance, de facto criminalization, and they go to another country where there's also de facto criminalization, then it's very unlikely, in fact, it's, I think, not going to be the case, that that other country would grant them asylum on this basis, because it won't perceive the same legislation or treatment that exists in its own law as persecutory. And what I argue in a short paper that I published on this blog is that, in fact, there is this gap, right, between what states expect in their own territory, it's the point I made earlier, and what they deem to be persecutory, the threshold that they send for persecution, which suggests that even when states are very protective, right? So say a state has same-sex marriage, right? It wouldn't set that as the benchmark for persecution. So it wouldn't say that somebody coming from a country where there's no same-sex marriage, but there are other forms of protection, say from discrimination or criminalization, they might say that's sufficient for saying that person is not persecuted. So there's always, I suggest, a gap. But it's also the case that within the spectrum of states that are signatories to the Refugee Convention, there are huge variations, right? So this is unlike some of the other categories in the refugee definition, where there wouldn't necessarily be a debate as to whether the category itself should exist. Should race be a ground for protection, or should religion be? Here, there's a debate as to whether the group itself has to be protected at all, right? Whether, for instance, if you've got a country where somebody is not protected from discrimination in the workplace on their sexuality, but there is no criminalization, right? And that person travels to a country which has full protection. That condition alone may be sufficient in that country, in that latter country, to get some protection, and it may not. And we don't know how the different perceptions of this group of persons, right, as needing protection, how those are to be interpreted by different jurisdictions. It's a very much a moving target, right? The case of criminalization that I mentioned earlier, the X, Y, and Z, is a case where the European Court of Justice said, we expect there to be enforcement of criminalization for somebody to claim persecution on this ground. It's not enough that there's a law in the books that says essentially you are committing a criminal offense by being and acting the way you are. even if it's not enforced. We want to see enforcement, right? That's obviously not the standard in any of the EU member states, but it was the thresholds that were set for persecution. So there's a really, I think, disturbing, but in reality, a feature and not a bug of the refugee system, divergence, both in terms of how states perceive people um, uh, and the condition they must enjoy in their country of origin versus the condition they set in their own domestic laws, but also simply in perceiving this category to begin with as a category of people who deserve protection. And this is perhaps the most stark example of different interpretations of the same document by countries that are all signatories to the Refugee Convention. So you take a country like Uganda that is hosting 1 million refugees, right? One of the top 10 in the world. It has one of the harshest pieces of legislation around same-sex sexuality. It's very clear that if somebody were to come to Uganda fleeing violent conflict, right? Meeting perhaps the definition in the OAU convention, right? Because of the conditions of the country, but they would be unsafe on grounds of their sexuality in Uganda, because in Uganda, not only are they not going to be protected from persecution somewhere else, if they are found out, they would be prosecuted on these grounds themselves. And so that to me illustrates where different human rights standards or different rights standards across the world have a crossover effect onto the ramifications for individual asylum seekers in different states. I hope that's kind of slightly stark or bleak picture is clear. And so the last thing I want to say before I kind of see if there are comments or questions or clarifications, and then we'll take a break, is about this notion of multiple nationalities, which I've also mentioned yesterday. This idea that because the Refugee Convention is a surrogate form of protection, then if you come to a country and you say, I want to get asylum because in my country of origin, which is also my country of nationality, I have a well-founded fear of persecution, the state may turn to you and say, but hold on, we are aware that you are legally also a national of another state, or that you may become a national of another state. You are eligible to become a national of another state. Why didn't you go there first to seek protection? And the basis for this would be Article 182 itself. It's to say that in the case of a person who has more than one nationality, the term the country of his nationality shall mean each of the countries of which he is a national, right? So that would apply to any country of which you have to show ultimately there's no country of nationality of yours to which you can go where you wouldn't suffer persecution. And what UNHCR has tried to say about this is that the way to apply this provision is to expect not just to have formal access to nationality, but to have in effect exercise of an effective nationality. So it is acceptable for state of asylum to say to an individual, you need to have approached another state to request that state for your protection and to be refused. If that has happened, then even if in the legal sense you might be deemed eligible for nationality in another state, if that state won't grant you protection from the persecution in that your state of origin or your resident, then you would be ineligible for protection. And there are two kind of prototypes of cases which have been litigated in the world. Perhaps one won't surprise you when I come to it. The first is that of displaced North Koreans, because all North Koreans, because of the one Korea idea, have a putative right to become South Korean. So they could, if they were to move, say, to South Korea, find the way to South Korea, they would be eligible for South Korean nationality. But the vast majority of them, if not all of them, when they flee North Korea and they end up somewhere else, they don't hold that South Korean nationality. And so for some countries, in some jurisdictions, in some cases, it was deemed sufficient that there would be eligibility for that person to go to South Korea to expect them to do so. Under UNHCR's model, the fact that you are eligible, but you haven't claimed yet that nationality at the time of applying for asylum, should be a barrier to make you ineligible for protection. So it should be the case that you already hold that other nationality. And the perhaps classic case of this was the case of Jews and historically some cases related to people fleeing the Soviet Union, particularly to Canada, in fact, where it was litigated, where Canada, the government initially tried to say, well, any Jew is eligible under Israel's law of return to become an Israeli citizen. So why don't you try that first? And the answer to this was that the law of return is by application. So it is true that there is a prima facie on the books. There is in principle a right to return and to obtain Israeli citizenship. But firstly, the law of return actually has some exceptions, which have very sparingly been applied, but there have been cases in the past, famously, where they were applied, for instance, to people who were deemed to be of a criminal persuasion. Some people, I don't think anyone here is old enough, even I'm not old enough to remember those cases from the 60s, but they did exist. And of course, it's a matter of application. So, once you've got something that is a matter of application, it is not automatic. So you're not born with that citizenship, but you have to apply for it. Then that's not sufficient, said the courts in those Canadian cases, in order for that to be perceived to be a basis for denying you protection under the convention. So this is where I think I would want us to pause, because that's the kind of bit of a whirlwind tour over the refugee definition and its different components. I've really only scratched the surface, as I'm sure you'll appreciate. There can be much more that can be said about each of these categories, but given our limitations of time, we can't do this, sadly. So I just want to see, before we take a proper break, whether there are any questions about any of these components.
Yeah,
Sure.
a little question. Is the application, isn't it a bit, far-fetched logic? Because it's an application, because every country needs an application if you want to enter into it. You can't just, you have to even make sure someone is a Jew. You have to applicate for it. You can't just go in like that. But it doesn't mean that if there is a Jew refugee fleeing for Israel or some other place, or North Korean fleeing to South Korea, you won't be getting in open hands soon, and then start the application maybe a little bit later, but will get citizenship and protection in the state that was more meant to him.
So I think the argument here would be that the distinction is between people who are automatically, by birth, for instance, say you're born in a country that grants citizenship on the basis of being born in that state, but you're also your parents, or one of your parents, comes from a country where you pass on nationality through the so-called law of the blood, right? So you sanguinis. So you might be born with more than one nationality, in which case, at that point in time, when you flee, say, your country of residence, which is your country of birth, another country might say you automatically were eligible to another nationality. Now, what might happen, and these are some of the contentious cases, you may have never activated that nationality, right? So it might be that you were eligible for another nationality from birth, right? So automatically, but you never applied, say, for a passport of that state. If you had applied for a passport, you'd be automatically eligible to get it, but you haven't done it prior to leaving your state of birth and seeking asylum in a third state. And then that third state might say, well, why don't you apply for a passport now? We'll let you stay, for a month or two or have you until that gets resolved. But once you get that citizenship, we will expect you to now move to that state rather than remain and get asylum here, right? So that would be a classic circumstance where you might not be able to activate your protection because you don't have the documents yet, but you are automatically eligible for them. And I think that's not such an uncommon scenario, in fact.
Okay.
Any other questions? Right. So I think what we'll do is should we take a 20-ish minutes break, right? Until about quarter two. So quarter two, in your case, I think 5, right? And we will resume then. And then we'll move to talk about displacement from conflict for the rest of today's session. So I will see you there. Right. So in this kind of part of today, hopefully this won't actually spill over to tomorrow, so we can discuss this question of displacement from conflict and the case study of Ukraine through temporary protection in one go until we finish today. Probably go without a break if that's okay, given today's session is a bit shorter. Let me share the presentation then. Just 1 second. I think this is it. Great. And okay, so what I want to do for the rest of today is to talk a little bit about why displacement from conflict has given rise to particularly, I think, fraught discussions in the literature, more actually around the Syrian civil war than more recently, given UNHCR's changed position. But why there was an initial sense that the refugee framework, so the refugee convention we've just been discussing, is not a suitable mechanism or not sufficiently suitable mechanism to deal with displacement from conflict. Why there is so-called, as Hugo Story, one of the UK kind of asylum tribunal judges, has called a war flaw in refugee law, or is there a war flaw in refugee law? And the answer I'm going to give ultimately is that it's not a flaw, but it is the case that some elements of this space from conflict are not well suited to a classic interpretation of the Refugee Convention. When the displacement occurs, I would say, well, I would argue in context of so-called traditional wars between two states of the nature of, say, Russia and Ukraine. And why, to that effect, the fact that the European Union proceeded to activate the temporary protection directive was both a good thing in many other senses, given the implication that had for efficiency and timeliness and attached kind of statuses for the wider remit or the wider net that cast, but also actually substantively avoided some of the dilemmas that a conflict like Russia-Ukraine would have raised, that in conflicts that are within states, the sort of conflicts like in Syria or Sudan wouldn't necessarily have arisen to the same extent. Much of this relates to our discussion before the break about the meaning of protection and what do we expect the state to do, and do we expect the state to always protect us from any harm? The answer is, of course, no. And so the context of an interstate conflict raises specific challenges in this regard that other conflicts don't. So this may sound a bit obscure at the moment, but hopefully it will be less obscure once I've unpacked it. But I want to start from where the original challenge lied. And the original challenge lied in this paragraph that still exists in the Handbook of the United Nations High Commissioner for Refugees, paragraph 164, which says the following. It says, persons compelled to leave their country of origin as a result, and they use here a slightly incorrect term. They say of international or national armed conflict. The correct international humanitarian law term would be non-international armed conflict for the second type, but leaving that point to one side, they say they're not normally considered refugees under the 51 Convention 67 Protocol, and that they have otherwise protections under IHL instruments. So under the Geneva Conventions of 49 and the additional protocols. And I've written on protections that exist, or particularly around reforma in IHL. So there's a valid point that there are protections, some protections, but obviously those conventions don't regulate the granting of refugee status. And so the idea that that's an equivalent, of course, is not sustainable. But the language the UNHCR has used here, it said that when people are compelled to leave because of conflict, they're not normally considered refugees. So that seems to suggest, right, if on a very plain reading of this, that you would expect most people fleeing conflict perhaps not to meet the refugee definition. And they, in fact, go on in the following paragraph and have an exception to that general statement. They say when there's foreign invasion or occupation of a part of a country, that could lead to persecution. So in those cases, the state itself no longer has effective control over that territory. So even if it wanted to protect you, it can't. And occupying state might persecute you, which is entirely conceivable. There might be grounds. You might resist it, right? You might simply, the basis for the occupation might be a battle between two ethnic states. And so, it might be that you belong to the other ethnicity. And so in those circumstances, we accept, the UNHCR says that, of course, persecution may occur, right? And so this framework, this initial positioning of UNHCR has prompted the idea that there might need to be something additional that people have to prove when there's displacement from conflict, when they're displaced from conflict, because just basing their claim for protection on the fact that they're displaced from conflict wouldn't be sufficient. And interestingly, based on pushback to this construction in the handbook, UNHCR published in 2016 guidelines on international protection, specifically dealing with displacement from conflict. I've cited earlier those guidelines when I spoke about the primacy of the Refugee Convention, but now I want to focus on the core dimensions of these guidelines, which is around, of course, the question of protection for people displaced from conflict. And UNHCR starts, and I say this very gently, because I have friends who work for UNHCR and I have respect for the organization. But I always say, when you need to clarify something, then that's not usually a good sign, right? Particularly not in a legal document. So the guidelines start by saying that they clarify paragraph 164. And why do they need to clarify? They say, well, we actually accept that, which is something that is an obvious thing when you read the 1951 Convention definition, is that it draws no distinction between refugees fleeing peacetime or wartime persecution. And they go on to then say in the paragraph, the phrase that we use in paragraph 164 So the idea that people are not normally considered refugees is intended to be understood as limited to situations where there's no causal link between a person's well-founded fear of being persecuted and a convention ground, to which, I, again, very gently used to say, well, duh, right? That's obvious, right? Because if there's no connections, there's no nexus between the reason for somebody's well-founded fear of persecution and a convention ground, then the convention definition is not met. So that just repeating the convention definition, it can't be that this is really what you've meant. And so I consider this to be an attempt at saving face, really, because the rest of the guidelines go on to rebut all of the premises behind this idea of exceptionalism or the normal non-application of the convention. So UNHCR starts by saying there is no high level of severity or seriousness of the harm that is required for the harm to amount to persecution in situations of conflict, nor is it relevant or appropriate to assess whether applicants would be treated any worse than they would maybe ordinarily be expected in situations of armed conflict and violence. And in fact, you can be in a situation where you've got conflict that can compound the effects of the harm on a person, and that can in fact give rise to harm that amount for persecution. So not only is it not the case that conflict means there is no persecution. In fact, it's because of conflict often that persecution is even more pronounced. So that's the first thing they say. Um, and in response to a claim that we should effectively, in context of conflict, defer entirely to international humanitarian law, so base our assessment of whether somebody is persecuted on IHL, they say, well, actually, that's not the case. And I agree with UNHCR here. They say you can have violations of IHL that can be informative, but it's not determinative whether conduct amounts to persecution within the meaning of the 51 Convention. You can have certain acts in conflict that are violations of the laws of armed conflict, but they're not persecution, and vice versa. You can have things that do not violate the laws of armed conflict, but would still be deemed to be persecutory under refugee law, because the questions refugee law and international humanitarian law are asking are different questions. International humanitarian law is concerned with a distinction between combatants and civilians. It's concerned with the type of weapons you use. It's concerned with proportionality. Those are different types of assessments than the assessments we're expecting in refugee law. And so UNHCR, I think, is right to resist the idea that the only measure we should use in conflict is, can we see violations of IHL? If we do, then there's persecution. If we don't, then there isn't. That's a wrong metric to apply. They go on to say, in situations of conflict, an applicant may be at risk of being singled out or targeted for persecution. Equally, there might be full groups or many members that are subject to the same type of persecution. They say the fact that members or many or all members of particular communities are at risk doesn't undermine the validity of any individual claim, right? So again, to draw back on my example of Yazidi women, there was a point in Syria and northern Iraq where Islamic State took control over certain areas, and essentially any Yazidi woman, and arguably Yazidis more generally, was in a position where they were going to be persecuted, if not worse, if not killed, by Islamic State. So the fact that that set of circumstances apply to all Yazidi women doesn't change the application of refugee law to each of those individual women. It might affect how you do the assessment, as we've discussed before the break. You might want to engage in a form of group determination rather than individual, but it doesn't necessitate that a Yazidi woman, has to show that she is even more targeted than other Yazidi women, right? That's not the type of assessment, type of measure that we need to apply. And indeed, that idea of a differential risk test is flawed, The UNHCR says the idea that an applicant is fleeing in a situation of armed conflict and violence, they're not required in those circumstances to establish a risk of harm that is over and above that of others that are similarly situated. This idea has no currency or basis in the Refugee Convention generally, and it shouldn't be applied here either. And indeed, to counter what may have been the impression of paragraph 164, which is that the normal condition in conflict is that there is no causal link between persecution and a convention reason. They in fact say in paragraph 33, in what I consider to be almost a screeching 180-degree reversal, they say situations of armed conflict and violence may be rooted in, motivated, or driven by, or conducted along lines of race, ethnicity, religion, politics, gender, social group divide, or may impact people based on these factors. And in fact, what may appear to be indiscriminate conduct may in reality be aimed at whole communities or areas where inhabitants are actual or perceived. Remember the point I made before the break about imputed characteristics. They may be actual or perceived supporters of one of the sides in the conflict, and rarely, so this is why I say there's a 180-degree reversal. They say rarely are modern day situations of armed conflict and violence characterized by violence that is not in one way or another aimed at particular populations, or which does not have a disproportionate effect on a particular population, which establishes a causal link with one or more of the convention grounds. So in other words, most conflicts, I read this to say, are ones where the type of violence that we see is one where that causal link exists, right? So this is all but to say the use of the word normally in paragraph 164 was wrong, but it's in the handbook. We're not publishing a new one, and so we will find ways to kind of skirt around it. Now that's me being a little bit cynical, but not too much. So where is um, the kind of the kind of more charitable view of where UNHCR was coming from? Why could you still say um, you can see where UNHCR is coming from? Um, so before I say this, the interim summary is that we've got persons who are displaced by conflict may be refugees. Um, in certain circumstances, a conflict may meet the definition of a conflict under armed conflict, but that's not relevant, right? Because the question for refugee law isn't whether the conflict or the violence we're seeing meets the definition of an armed conflict within international humanitarian law. It's not a relevant question. It's a relevant question for other purposes, but not for refugee law. And whilst not all persons who are fleeing conflict may satisfy the Refugee Convention definition, they may be entitled to protection on other grounds. And we saw the regional protection regimes are very clear that they make references to displacement from conflict as a positive reference, in the sense that they acknowledge it as a set of circumstances that may give rise to protection needs. So to go back to my earlier point, what can be nevertheless the charitable view that supports a UNHCR type reluctance, or the historical view? And my assessment of this, and this is me, right? So other people may disagree, including in the refugee law community, is the UNHCR had in mind the sort of conflict that is now rare, that is a classic interstate conflict, right? A conflict where I say rare, bearing in mind that it may not be in certain parts of the world, including yours, it's not rare, but as a overall picture of conflicts around the world, most of the conflicts today are not conflicts between two states or more than two states. They tend to be conflicts that are non-international armed conflicts. They are between armed groups and the state, or between different armed groups within the state. UNHCR, I think, had in mind a conflict like Russia-Ukraine. And in a conflict like Russia-Ukraine, and I'm leaving aside for a minute, which I'll come back to afterwards, the question of the occupied parts of Ukraine now by Russia. Thinking about you know the situation in a place like Lviv or Kiev, right? So situation in the mainland of non-occupied Russia, where Ukraine is governing, where Ukraine is seeking to defend its population. The relationship between an ordinary Ukrainian and their state is not a relationship of persecution, right? It's not a relationship where the state is seeking to persecute them, nor is it a relations where the state is unwilling to protect them. It's very much wanting to protect them. And again, this would be the debate, I think, but it's not also clear that the level of threats that people face, and that may depend in different parts of unoccupied Ukraine. So it may depend, it may be different in Kharkiv than it is in Kiev, than it is in Lviv, and it is in Odessa. But it's not obvious that the level of threat is one which we would consider to be a case of the state being unable to protect persons. So can we expect the state to deliver on 100% protection from harm? No, we can't. That would be unrealistic in a context of conflict. Does the fact that there is some harm suggest the conditions under the Refugee Convention are met? Not obviously, right? And the same can be carried, by the way, if one were to think about missile attacks on Israel. The state is obviously trying, at least within its recognized pre-67 borders, to protect the entire population. It's doing a debatable job. People would debate, how successful the protection would be in shelters and what have you. But it's certainly not engaged in trying to to persecute rather its population, nor is it unwilling as a matter of principle to try and protect them. It's wanting to protect them. How good a job it does is questionable, but is it at a level that would mean somebody leaving would be entitled to protection under the Refugee Convention during that conflict somewhere else? I think my own refugee law interpretation, very debatable, right? And so if we think about it in the context of the situation in Ukraine, I think there's a clear, stark distinction between occupied Eastern Ukraine and the rest of Ukraine, right? So in occupied Eastern Ukraine, the conditions in paragraph 165 of the handbook apply, right? You've got Russia essentially now in effective control. By definition, Ukraine has no control over these areas anymore. The population there, to the extent it hasn't been ethnically expelled, or ethnically cleansed, which has happened in certain places, is clearly antagonistic to the Russian occupying forces. There are various persecutory acts, including the banning of use of language in various contexts, taking away books from libraries, various forms of harassment, things that would amount to persecution, and there is no state protection from that persecution. So my own view is if somebody manages to flee Donetsk or Luhansk and to get somewhere else that is convention signatory, they would be eligible as an ethnic Ukrainian to refugee protection. And the ground under the convention, you might even say is the nationality ground. Russia, of course, contests this because he doesn't believe there is a separate Ukrainian nation. So Russia may be engaged in a form of imputed political opinion to those who oppose its rule and consider it to be anti-Russian, right? So I think Eastern Ukraine is an easy case, or the occupied parts of Eastern Ukraine. I think the difficult cases, as I say, are places in Ukraine that haven't been occupied, but have been bombarded quite frequently by the Russian forces. And here, I think what we see as a matter of course, I mean, of course, a lot of the Russian attacks are targeting military installations or dual use installations, but some of them are indiscriminate. Some of them may even be deliberately targeting civilians, which, of course, is itself a breach of the laws of armed conflict. And in the face of those attacks, the Ukrainian state is trying to protect its civilian population, right? It has air raid shelters, it has sirens, it uses some forms of air defenses, it's seeking to protect its civilians. It's not always succeeding, right? Um, can people move within Ukraine to other parts which are less threatening? Possibly. Can we expect people to do this on the promise that that area won't be targeted? Probably not, because um, Russian attacks are sporadic, right? And they can happen in other areas, and they have happened in not as frequently, but have happened in places like Lviv and Odessa, and not just in Kiev or Kharkiv, etc. So um, it's complicated, right? So my view is about Ukraine is that if the EU hasn't done what it's done with temporary protection, if it had Ukrainians come to the EU seeking protection under the Refugee Convention, some EU countries might have found it quite challenging to apply it, at least to apply it consistently with their approach to armed conflict in other or to persecution in other contexts, and the notion of availability of state protection, which is why they might have resorted to the mechanism of subsidiary protection, right? So as we know, from earlier today and last week, not last week, yesterday rather, um, Article 15 references specifically situations where somebody faces a real risk of serious harm because of serious and individual threat to their civilian lives by reason of indiscriminate violence in the context of conflict. There's obviously an international armed conflict between Russia and Ukraine. There is indiscriminate violence in many places. Does that pose a serious and individual threat to civilians? Certainly in large parts of Ukraine, you could say the threat is serious, and the threat, and there's real risk of it. So my anticipation, this is entirely speculative because we haven't ended up with this being the case, but that if there hadn't been an activation of the Temporary Protection Directive, what we would have seen is en masse granting of subsidiary protection to Ukrainians in the European Union, because countries would have skipped over refugee assessments. They would have said this is a conflict situation that's difficult to apply the convention definition, and we would go to subsidiary protection. If we think like, because I said earlier, and I then want to pause and see if people have comments on this or contestation, etc. But I said earlier that in like in the majority of conflicts, which are non-international armed conflicts, the convention would be a much more straightforward form of application. So I've given one example, right, which is Yazidi women. Another example would be people fleeing Sudan today. There's a clash between two groups. The targeting of members of one group by the other is based on ethnicity ultimately within the meaning, on the fact that they are members of that other group. There is no, as a result, functioning state that can help the side that is being attacked. I mean, in one case, it might be nominally the side that the state itself that's doing the attacking. In another, the attack may be against the institutions of the state, but it's ultimately an attack against ethnic groups in both instances. And so here, the fact that this happens en masse in the context of conflict doesn't change anything, right? It's the case that the refugee definition um, is directly applicable because you've got people facing what we would deem to be persecution in the sense of serious harm, physical harm in many instances, if not worse. And they have no effective protection to turn to within the state. So those are the classic. So in a way to sum up this point, my own view is that I understand, although think it's still conceptually a mistake to keep the framing in the way it is. I understand where paragraph 164 comes from. I think it is the case that our traditional view of, I don't know, the Blitz wouldn't have been that um, British persons were under well-founded fear of persecution in Britain when the Germans were bombing, right? There would be an odd type of understanding an interstate conflict. So I get that, in other words, but I also practically think that it is wrong um, to have a framework that doesn't accept that in today's conflicts, most conflicts are like Sudan and not like Russia, Ukraine. And that's exactly what the UNHCR has done with its guidelines. So with the guidelines, it's moved away from that rigid approach in the handbook into a much more contextualized approach, which is correct. So the guidelines, I think, are not at fault. But the combination of the two still creates an unhelpful confusion in this field, which is what I tried to unpack here and resolve. So before I go to the activation of temporary protection for Ukrainians, any questions or comments on this?
I'm not quite sure what you were saying that most conflicts are like Sudan and not like Russia, Ukraine. Could you maybe touch upon that again?
Yes. So Russia Ukraine is, if you think about it, a classic, historically a classic conflict. A classic armed conflict was a conflict between two entities, two recognized entities in international law, two states, sometimes more than two states involved, right? The world wars obviously are examples, but often just two individual states. Iran Iraq, right, was an 8 year international armed conflict between two states. In those circumstances, or I don't know, the Six-Day War, Israel Egypt or Israel Syria, where Israel Jordan for a few days, right, in the space of the relevant days, were international armed conflict. In those circumstances, the population of the state is not threatened by the state itself. It's protected by the state, so the state is attempting to protect it from an external threat to the state that's coming from outside. Whether it does so successfully or not, as I say, is may dictate whether we deem a persecution threshold sometimes to be crossed, but ordinarily you wouldn't be. So I think ordinarily the word normally here makes sense to me, at least. The context of most conflicts today is conflicts between the state and organized armed groups within the state, or between different armed groups when the state is really dysfunctional. So we think Somalia, we think the DRC, we think Sudan, we think Cameroon, we think Syria, we think to a lesser extent Myanmar, although because Bangladesh is not involved, so arguably Myanmar as well. Afghanistan in the period where the clashes were only within Afghanistan. So in those sorts of circumstances, you've got one group within the state being targeted by another group within the state. And so the state is either itself engaged in persecution, or people who are identified with the state institutions are targeted by the other group. But the state is not necessarily able to protect them from that other group, right? It's a factual question, but if the state might be too weak to be able to protect them in those circumstances, right? So that's the distinction I'm trying to draw, and I think is reflective in perhaps even intuitively we would consider circumstances where the state itself is under an external threat from which it's trying to protect its population as different than a civil war, right? We might instinctively think those two are from an external actor's perspective, right? An external state needing to see, does that person need protection? they would consider those circumstances different. As I said, Ukraine is interesting because even though it's a classic conflict, um, the European Union, which I'm about to come to, has not thought to draw a. Firstly, it activated temporary protection, but also it has not thought to draw, for instance, a distinction between occupied areas of Ukraine and others, or between different periods in since the full scale Russian invasion in February 2022, but in fact has immediately and unequivocally and unreservedly and in an unqualified manner provided protection for Ukrainians, and that's an unusual case, right? It's hasn't happened before, and I'm not persuaded will happen again. But it's a fascinating case to be, I think, assessing, which is why I want to do so now. Um, so firstly, what is this framework of temporary protection? So if you think back to one of my slides yesterday, I was saying the EU had three forms in its asylum kind of overarching document. It talks about three forms of protection: about asylum, which is refugee status, about subsidiary protection, and about temporary protection, right? And those are distinct form of protection. So temporary protection is a concept that exists in EU law since 2001. So it exists 25 years, and the origins of it was the realization that what has happened during the wars in the Balkans was a bit messy. And it was a bit messy because at that time, the EU didn't have a unified asylum policy, and neither did it have any mechanism to deal with situations of conflict where there are large numbers of people leaving a certain territory in a short space of time and needing protection, right? It had no mechanism of that nature, not in relation to people fleeing Bosnia, and not later in even larger numbers when people were fleeing Kosovo. And so in 2001, in the aftermath, it decided to adopt this temporary protection directive. And the rationale for this was a pretty straightforward one, right? It's precisely related to the discussion we had before the break. If you're going to engage in individualized assessment, it takes time. If you have large numbers of people coming in a short space of time, it's often impractical. It's often very difficult, might leave people in limbo for a long time, might be resource intensive, but it also may be not the sensible thing to do. It might be that conflict is different than your political dissident situation. Political dissidence may last, sadly, very long times, maybe decades, maybe for your life, if the regime never changes. Conflicts usually end quicker than that. And so there might be good reason to think about protection in conflict situations as necessitating a different approach, which is more group based, less individualized, more immediate, and less secure. So less long term, less permanent, right? Not that refugee status, as I said, is permanent, but refugee status is indefinite. Temporary protection, as the name suggests, may indeed be intended, very much so, to be temporary, right? And so the interesting thing, of course, is that Europe or the European Union has had people fleeing to its territory from other places that had conflicts in large numbers in short spaces of time in the 20 years between 2001 when this was adopted and 2022 when Ukraine happened, right? Syria, Iraq, Afghanistan. And there was never the political consensus to activate this temporary protection directive. The reason for this is that you need political consensus because under EU law, it can only happen if you have what's referred to as a qualified majority, so bigger than your ordinary majority in the European Council of EU member states. In order to activate it, there needs to be a proposal from the European Commission, and in none of those cases in the past has there been the political will to do so. We can speculate later as to what differentiates the type of refugees coming from Ukraine and those who've come from Syria, Iraq, Afghanistan. But the political reality is this, that this was the first time in which the activation has happened, and it's happened, to those of us who follow EU procedures closely. It happened in an admirably fast and efficient way, right? So the EU is not well known for its quick, efficient procedures, but in this instance, within 10 days from the invasion, the Council of the EU, acting on a proposal from the European Commission unanimously, even Hungary under Orban at that time, um, agreed to activate the Temporary Protection Directive. And in order to activate the Temporary Protection Directive, the standard you need to meet is one of having a mass influx. So this is the legal term that's used in the directive, of displaced persons. And the definition that is provided in the directive is that mass influx is the arrival in the EU of a large number of displaced persons who come from a specific country or geographical area, whether that arrival was spontaneous or whether it was aided. Right? So that's the interesting thing. Like, it can also be a case where the European Union, for instance, in one form or another, engages in airlifting or rescuing people from a war zone that would bring them to the territory. That itself could also activate temporary protection. But of course, the more usual scenario is, and the one that transpired in the case of Ukraine, is that the arrival then becomes spontaneous. People simply come to a border crossing and seek to cross it. So a question around eligibility. The interesting thing in this directive is that it says the whole of Ukraine is included. And what that means is that there is no question, as I say, that is being raised of internal flight or protection alternative. The second thing is that it applied to any Ukrainian national who was living in Ukraine before the 24th of February and who then left Ukraine, right? And it continues to apply to them to the extent that somebody can leave Ukraine, can leave Lviv, right? Come to Germany, get temporary protection, get the rights that I will come to that attach to that protection, and then return for a certain period to Lviv, say to see other members of the family, and then cross again. And the fact that they have spent periods again in Ukraine does not invalidates their temporary protection. And that is very different, as we will come to see when we talk about cessation of refugee status, from the approach to refugee protection, where the assumption is that at the very least, long-term return to your country of origin would invalidate your refugee status. With temporary protection, since temporary protection was activated, which was the 4th of March 2022, until today, many Ukrainians have done a return trip and have returned back to the European Union. That has been a fairly common occurrence. Not everyone, of course, and not perhaps even the majority, but very many have. And that's been made possible under the Temporary Protection Directive. Importantly, and very unexpectedly, I would say, from refugee community, temporary protection was also extended to people who are citizens of other countries, not EU countries and not Ukraine, or people who are stateless, who were living in Ukraine at the time of the invasion and were unable to, at that time, to return to their country of origin in a safe and durable condition, right? So imagine you had someone who was studying in Ukraine, to relate to the discussion we had yesterday about Refugee Sul Plus. Somebody who's still doing their medical degree in Odessa, and is from Syria, say, and he's unable. They are actually there to study medicine, but they're unable to return to Syria. If the invasion of Ukraine hadn't happened, they would have just remained in Ukraine and continued to study, but they can't. So they flee to a European Union country and they get temporary protection as if they were Ukrainians, right? And further on, this extend also to those who Ukraine has granted refugee status or equivalent protection, or to people who are in the process of seeking asylum in Ukraine. They were all co-opted into the temporary protection in the European Union. This is very significant. And Ukraine, by the way, it's a less known story, but Ukraine was hosting large numbers of people from countries where there are conflicts, either as students, very very commonly, or indeed as asylum seekers. So there was a not insignificant number of people who were holding that status in Ukraine, and as a result became now eligible for European Union temporary protection. So very interesting move by the European Union and I'm not sure it was fully understood or realized the scope of the application of temporary protection when it was done in this way by the lawyers in Brussels to be. But I think quite notable. How does the Temporary Protection Directive then relate to or speak to the 1951 Refugee Convention? So the first thing is that the right to temporary protection, once the directive was activated, was immediate. So as soon as you crossed into a European Union country, you became eligible for temporary protection. And essentially what this did was it put refugee status on hold. So it put refugee status under the 51 Convention as something that in the future may or may not need to be assessed, but states that grant temporary protection are allowed to tell a Ukrainian, even if you want to have refugee status, which, as we've discussed earlier, has an advantage of having more long-term security because it doesn't end unless a specific circumstances occur under cessation clauses. The state is allowed to say no. It's allowed to say, we have decided to go down the route of temporary protection for a reason. We're not assessing individual asylum applications from Ukrainians. So ultimately, no European Union country has undertaken refugee status determination of any Ukrainian since March 2022, which was entirely to be expected and permitted under the directive. And so, in theory, people could apply, but member states have delayed considerations of those applications. The Temporary Protection Directive is quite remarkable in setting minimum standards for temporary protection that include access immediately to health services, to education, to welfare, to work, to the right to work from day one, to housing. So well beyond just non-pushback or non-reformer. And in fact, if one reads the list of rights that are guaranteed to people who get temporary protection and the list of rights that they get if they are recognized as refugees, the only substantive distinction is around temporality, which is a significant distinction for the reasons we've articulated, because there is, at any given point in time, a thread hanging over their head, right? Essentially saying, if tomorrow morning Vladimir Putin, Vladimir Zelensky meet and decide to sign a ceasefire agreement, does that mean I have to go back, right? We shall see, right? We'll come in a few minutes to what happens if and when temporary protection ends. But bar that scenario, right, at the moment, and from day one of them having arrived in the European Union, they were entitled to the whole slew of rights and protections. And the big difference that temporary protection directive encapsulates from the refugee protection regime more generally is that it adopts measures that are intended to promote a balance of efforts between member states in receiving those persons and in bearing the consequences. That's considered to be code for responsibility sharing. So ultimately, states that ended up with having more Ukrainians get some form of European Union financial support to acknowledge that there is a cost involved in having in having more people in need of protection. And fundamentally and importantly and differently than what we see in other contexts of refugee protection, the people receiving protections themselves have the right to move between EU member states and to take with them, as you were, when they do their temporary protection status. So the EU, received a lot of praise for acting decisively, rapidly, with unanimity in this process, right, of granting protection to Ukrainians. There's also been a degree of criticism for the fact that there was no responsibility sharing mechanism of a proper nature, and indeed no temporary protection in previous crises. So one question, and this was early on this was in the 10 days before the temporary protection, which is I thought quite a notable sign um, that caught my eye at the time. Um, so what still explains the distinction in the approach of the European Union? So as I said, there can be, and I'm sure if we get to that in discussion, there will be people who will say ultimately it's about the type and nature and character of the people arriving. That's the main distinguishing feature, and proximity, in other words. But there is also a substantive legal difference that made an impact here, in my assessment, and that is that in relation to all of those other countries where there are conflicts which we can think of, which are refugee producing and which have arrived in Europe. So Syrians, Iraqis, Afghanis, Eritreans, Sudanese, um, Ukrainians before the 24th of February 2022 had what's referred to as a visa-free temporary access to EU member states. I believe of the nature that an Israeli citizen has in the European Union, right? So the idea that you can enter as a tourist for a 90-day period in each 180-day period without requiring a separate visa, which means you can arrive. I mean, now there's going to be a verification system where you have to apply for electronic verification, but you are in principle eligible just by virtue of holding a certain nationality to enter the European Union for a short period. And so my assessment of this was that people very quickly understood, and in fact, they didn't need a long time to understand this because as the war started, I'm sure all of you remember the pictures. There were these massive overpacked trains getting to Lviv from other parts of Ukraine and then proceeding to the border with Poland primarily, but in other parts of Ukraine, trying to cross by other means, by cars and otherwise into Hungary, into Moldova and elsewhere. Um, and so there were large numbers of people who were crossing, and the European Union countries could not turn away someone at the border because they had a right to enter as a Ukrainian, right? So ultimately, what would have happened if Ukrainians were not allowed or were not given temporary protection was they would have forced the European Union into a process where they would have needed to undertake individual assessments or, some form of wider group assessments, maybe under subsidiary protection. But they couldn't at that point engage in reforma in return, and they couldn't close their borders because legally Ukrainians were eligible to enter the European Union. Whereas with all of those other countries, the first thing that many European Union countries did when the civil war in Sudan had reignited in 2023 was to close their embassies and to revoke any visas that were issued. And this is the tragic and terrible reality, which I will come to tomorrow, I think, when I talk about externalization and visa practices. It's it's the case that nobody expected Ukrainians to need to get protection in the EU, and hence they were allowed to enter. Whenever there's a country where you expect people to might need protection, you very quickly take away the right to enter without a visa, right? That's the cynical, terrible reality of the international regime. And so that's the legal explanation, right? The legal explanation is simple, that Ukrainians were different than all those other countries in the sense that they had a legal right to enter. And as a result, the European Union took a very different approach to movement as well. Actually, once people are allowed to enter the European Union anyway, actually it became in the interest of the European Union countries that the burden won't fall on only the frontier states. So it's not Poland or Hungary that have to be the only ones, or Moldova to share the burden, that it should be possible for other European Union countries to take in, or for people to move to other countries in some managed way. And so the European Council decision says Ukrainian nationals as visa-free travelers can choose the member state in which they want to enjoy the rights that are attached to temporary protection and to join their families and friends across the significant diaspora networks that currently exist across the Union. Now, the same logic, the same explanation, you change the word Ukrainians, there are diaspora communities of Syrians or of Afghanis or of Iranians or of Eritreans in various countries. That may mean that somebody who has entered, say, Italy, would want to get to Germany or to the Netherlands or to Sweden or anywhere else in the European Union where those networks exist, but they can't, right? Because the European Union mechanism generally would not allow you, once you've entered the EU, to continue your journey, in the sense that if you did so, the country that you ended up coming to could return you to your first country of entry. This is called the so-called the Dublin regulation mechanism, right? The Dublin regulation mechanism generally in the European Union says the responsibility for assessing an asylum application falls on the first country in the European Union that you have entered. And that tends to be the frontier countries, the Mediterranean countries, so Greece or Italy or Spain or Malta. It sometimes was a land border country like Hungary, or in a lesser extent, Bulgaria, and others, right? Before the Ukraine war, also Poland, right, which had people trying to cross its border from Ukraine who were not Ukrainians, and were stopped, right? People tried to cross from Belarus into Poland who were stopped, right? So the model here was an entirely. It's almost like the whole thinking around asylum has flipped, right? The thinking here was, let's make it easy for people to move between EU member states. Let's reduce the burden on one member state. Let's give rights immediately so that people can integrate easily. Let's not go into an individualized assessment. Let's just give everyone protection because that would ease the administrative burden. So the whole approach, the whole framework, is unique in being so contrary to any other asylum practice that we can think about, or think of in recent years, that it's quite striking, in fact. And so what I want to leave us with for a few minutes, before we close for discussion, is what happens next, right? So the notion of temporary protection initially was that it was supposed to be temporary, and the directive, in fact, says it's supposed to apply for 1 year, and it's renewable, but it has to be renewed each year. So each year you undergo an assessment on a European level whether that's still needed. And the last assessment was done, and the assessment was that the war is continuing, and so it was renewed until March 2027. But that's less than a year away, right? And we don't know. The world is very unpredictable. The war may end, right? And what happens then, right? What happens when temporary protection ends? What weight should be granted then to the fact that people have resided in those countries, albeit knowing that they have come in under temporary protection, but at the same time they had no other option, right? They were not offered the possibility of applying for asylum as refugees. Um, Also, they even if they had done that, right, as refugees, now 5 years, let's say the war ends next year, 5 year will have passed. Say you've got somebody, an adolescent teenager who has arrived at age 14. She went to school in a new country. She studied a language. She has friends. She connected. She's about to start university studies. Should she be sent back, right? And so that's a deeper question, right? Which I will want us to come back to when we talk about cessation of status as well. But it's particularly profound here because the numbers are staggering, right? So I think Will made this point yesterday when we talked about this, right? We had millions of people arriving in a short space of time in the European Union. In some countries, it's a sizable part of the population, right? In Poland, it's probably the equivalent of about 3%, 3 to 4% of the population. Um, Many of them are now integrated into their respective societies. But at the same time, it's quite a sizable foreign population, right? And I think the other big question that we want to probe is a group like temporary protection the inevitable or indeed just a suitable response when you've got these situations like a mass influx scenario? And what are the costs? What are the benefits of having these sorts of policies? So those are some of the thoughts and questions I wanted us to think about. So I've spoken enough. So kind of inviting any thoughts and contributions on this, on what you've picked up from this model.
Yeah.
Yeah, go ahead.
So, because the situation in Ukraine is happened because of the specific civilized or visa structure of the European Union, it doesn't essentially have any effect, legal effects, and so on other conflicts that happens around the world that don't touch Europe.
What do you mean doesn't have any legal effect? So
I mean,
what do you
their
mean?
interpretation of how they should deal with the Ukrainian refugees and the whole legal structure they constructed fast to as an to as a result of the war doesn't have any. It wasn't like a sort of an interpretation to the Refugee Act. It was because of the visas, how it's you are able to pass between different European borders and the will to not have it all land on certain countries. So
Sure. Yeah, go ahead. Sorry.
yeah,
Yeah.
so my question is if it has maybe I missed something, but if it has any effect, or if there is suddenly a war and there is a next amount of refugees on a war between China and Vietnam or something, if something that happened to what happened to Ukraine will affect it or not, according to
Okay.
Refugee Act?
Yeah, well, I think that's a really good question. So I think there are two ways of thinking about it. I mean, one is to say for the EU itself, um, the temporary protection directive is not country specific, right? So it sets out terms for when it makes sense for the directive to be activated. Once it's activated, then the legal consequences that happen with Ukraine follow. The reality is, for it to be activated, there is a political mechanism, right? Which is that the European Council So the different member states have to agree, not all of them, but at least the qualified majority has to agree. And if they don't agree, then it won't happen, right? So, and there's no way, and this relates to your point, there's no way of forcing the European Union to activate the Temporary Protection Directive, because it's ultimately the choice to activate it, and the ramifications is political. As a result, it doesn't have an immediate direct effect, in the same way as you say that if you say had a group of people coming from a certain country, where the refugee convention itself was interpreted in a certain way in relation to that group, that, from a consistency perspective, would have had an effect, right? If you had a group coming from another conflict under similar conditions, right? So conditions of certain indiscriminate violence or otherwise, right? So on that front, you're absolutely right. And I think that is a challenge, right? So one can call out potential hypocrisy or otherwise of the EU. One could say, actually, it's not hypocritical. It's different when it happens literally on your border, when it affects your countries, when it's a country that was on the verge of potentially becoming a candidate state to join the European Union, may still join the European Union, has ties to other European countries, has a history where places like Lviv used to be part of Poland. So there, I think there are arguments both ways, but the reality is, as a practical matter, unless a majority, unless a political majority, a relevant political majority in the European Union decides in a future conflict to do the same thing, then it won't happen, right? The interesting question, that's the second dimension, is what does that do for places elsewhere in the world that have a conflict on their doorstep, in terms of their own approach to whether it's desirable to treat people fleeing those conflicts in a ways that's similar to the way the European Union has done or not, right? So whether they see this as a model that they would want to follow. What are the benefits, as I say, and costs of that? So arguably, one big benefit is that it's administratively much easier. You just give people a form of protection. You don't have to go through an individual assessment. You give them rights which ultimately allow them to integrate more easily, and you limit it, you time limit it, right? You say, I am not guaranteeing you the right to stay post-conflict. Be aware, I'm offering you temporary refuge. So that, from some states' perspective, that might be beneficial. The the con is that by applying something like this, you are much more likely to have a much bigger population come in, right? So if you have a choice and if you're able to fend off your border, you may not want to do that, right? You may say what the European Union has done, will now make it very difficult to actually return people, even if the conflict does end, because what will happen next, which people like me would say is the desirable outcome, is that if a country in the EU wanted to return that 14-year-old, now turned 19, to Ukraine, there might be human rights arguments for why that's not an appropriate thing, why it's more appropriate to allow her to apply for a study visa or for a work visa, and to be able to stay on those visas rather than otherwise. So I think that's the second answer. The second kind of strand from your question is, uh, this is such an unusual practice, in many ways an admirable practice, but perhaps so admirable that it's unlikely to be followed. So maybe unlikely to become a precedent, right? And I think that's the interesting dimension here.
Mm.
Any comments and questions from other people?
So I think maybe a concern is that this kind of this procedure essentially just delays the problems, right? It doesn't really, I mean, it gives them short-term protection, which is really efficient, effective maybe, but it's not like the EU countries have started to process refugee applications at this point.
Yeah. Well, that's exactly right, right? So we can imagine. Let's imagine we get to a point where there is a ceasefire, but um, a lot of people had their houses destroyed, or you've got people who lost family members who are unable to live a dignified life, kind of going back, or who have other reasons to not want to go back to Ukraine because perhaps they are worried from grounds of retribution. They might actually be ethnic Russians who lived in Ukraine because the EU Temporary Protection Directive didn't distinguish, right? So it didn't say if you're a Russian speaker from Ukraine, you're not allowed in. So they might fear that if they now were to return to Ukraine, given the level of hostility between two countries, it might subject them to press. So in other words, you might end up, even at the point the conflict ends, you would have to, by necessity, um, allow anyone who now wants to apply for asylum. So unless you did a blank transition of everyone into a different secure status, if they wanted it. I mean, many people may want to return, right? But for anyone who wanted to stay, automatically gives them long-term residency, which is a status that exists in EU law. That would be the easiest solution if I'm not a prophet after the destruction of the temple, but if I were to prophesize, I would say that this is what will happen. That the European Union would say anyone who wants to stay will get long-term residence. But if they don't, then those who want to stay and want to do so on the basis of asylum, you would have to allow them individually to apply because the temporary protection, as you correctly put it, delayed but didn't displace, to quote a phrase, the procedure under the 51 convention. So that's one of the challenges, right? So it may still be sensible, right? It may be still the correct thing to do. It certainly was the most generous interpretation of temporary protection that anyone could have thought of, given it was extended to even to people who were not Ukrainians who lived in Ukraine, was also extended to their family members, to their spouses, to their children. So if you had somebody who was not Ukrainian, who was Ukrainian but had a non-Ukrainian spouse, they also got temporary protection. Um, so quite a generous scheme. But Ukraine might be an unusual case, right? It might be a case where um, the assumption is and was that it's borderline an EU country, right? It's on the verge of becoming one. In fact, this war might have made it more likely that whatever happens after it, whatever parts of Ukraine remain Ukraine, will indeed end up joining the European Union. So the EU might have thought about it through that lens as well, right? That relates to Evyatar's point, I think, to a certain extent. So yeah, I think, but I think you're to kind of conclude this point. I think you're right to say that that's potentially a con for the states, that they are simply delaying rather than concluding, the status by having temporary protection. Any other comments from anyone?
Is
Yeah, go ahead.
one last one. Is proportionality a legitimate consideration when applying refugees? For example, if you say like there's this 14-year-old girl that is somewhat, you say, contributing to the state and is more perhaps integrated than other people. But on the other hand, if she, say, a 50-year-old Muslim migrant from Syria, will return to their home, they will be faced, say, the same persecution, for the sake of argument, the same level, be it high or low. But is it okay according to Refugee Act to say, well, because she's more integrating better, or maybe because we want her better, it is a legitimate argument for us to leave her and kick the 50-year-old Muslim Syrian out? Or is it only if they're the same level of prosecution in the state that's the only thing that should matter? I mean, if so.
Yeah. No, I get your question. I mean, I think it's a good one. I mean, I think I want to discuss this. It's not a specific question about temporary protection or about this, right? It's a wider question about when refugee status comes to an end and what happened then in terms of the state's assessment. So I want to come back to it more fully when we talk about cessation. In the process of granting asylum, it absolutely is not supposed to be one of the considerations, right? So, of course, if somebody committed crimes that make them excludable, then then they'd fall under exclusion clauses. So that's a separate category. But the fact that somebody may or may not end up integrating, right? So in the future sense, that shouldn't be a consideration. At the time of cessation of status, it's a more complicated question. So under refugee law, the strict answer is that it's not. But under the wider human rights framework, right, of what you consider to be the prerogative of the state for people who are long-term residents, whether at a certain point states can exercise migration control, as we know, questions of integration do play a role in whether people are granted permanent residence, whether they're granted citizenship. Whether that's justifiable or not is debatable. The distinction I would draw here is between refugee law, strictly speaking, where this is not a relevant consideration, and wider frameworks of protection, where I think, as a matter of the state practice, it is. I think we should return to this because it's an interesting dimension. The whole question of integration and how one whose duty it is to integrate, the state's duty to integrate the refugees is to the duty to try and integrate into the state. What does that translate to? What happens if they don't? Those are good questions. So let's park them for the cessation discussion, and we can come back to them. Great. I think we've come to 4 o'clock mine, 6 o'clock yours. So we will stop here. We are meeting tomorrow, I think, back at 2:30 your time. So I would send hopefully the correct Zoom link. I wonder if I should.
What hour tomorrow?
I think tomorrow is 2:30 your time. Yeah. So because it was only today there was a different time. So the rest of the week is all at 2:30. So I will see you then, and I'll send a message with the information. Take care.
Right. Thank you.
Bye bye.
Thank you.